Good morning. It's Legal Access brought to you by the Maguire Law Firm. Today we're going to be talking about workers' compensation. If you've been hurt on the job at all, if you have any questions about what you should do, what you shouldn't do, or if you're an employer, make sure and give us a call today. We'll give you all the answers that you need on our panel to answer all your questions about workers' compensation today. From the Maguire Law Firm is Ian Maguire.
Good to see you, Dave.
Also from the O'Neill Law Firm is Rick O'Neill.
Good afternoon, or good morning, I guess.
Yeah. And on the end of the panel there, also from Maguire Law Firm, is Tiffany Bufkin.
Nice to see you, Dave.
And Ian, we just saw you a couple minutes ago on this very station as you were talking about the Summer Without Hunger that Maguire Law Firm is doing with the Salvation Army and WMBF News. So I know that's something important to you.
Yeah, it is, and really to the community, because you know we don't realize, at least I would not have thought that there'd be so many kids in need of food in the summertime. So a lot of children are actually getting their meals through school. That's where their main meal's coming from. And so when the summer comes, there's a deficit. And so we are trying to do what we can. We're working with the Salvation Army and WMBF to have a food drive to make sure that all the kids in our community are fed. And you know, it's
right.
Basic fundamental thing that every child should have food and shelter, and so we want to make sure that happens. So if you want to donate, you could donate directly financially to the Salvation Army here in Horry County, or you come by our office at 1600 North Oak Street and drop off any kind of snack or perishable item that non-perishable, item, you know, such as canned goods, and we'll get those to the kids that need them. So yeah, it's unfortunately, and we talk about hunger a lot on this show, and there's a lot of charitable organizations that do such a great job. The Community Kitchen, for one, and Helping Hand, and you know, it's such a fantastic community, and there's so many great things happening. But it's a tourist town, and there really are people that struggle, people that even are working, that you know, just can't make ends meet, and they go to Community Kitchen in the mornings for food. So that's another great place to donate both your time and if you have the ability to contribute financially to do it. So anyway.
Absolutely, another great cause, and if you need more information, you can go to the WMBF website, or just stop on by Maguire Law Firm, again, the corner of 16th Avenue North and Oak Street in Myrtle Beach. Now, talking about workers' compensation, let's go ahead and get to our topic at hand today. If you have any questions, the phone number is on your screen, 843-848-8080. Now, if somebody is hurt on the job, where does it need to rise to before you really need to get in touch with your employer? Do you need to be to the point where you're hurt too much to be able to work, or you've got to go to the hospital, or what do you need to do if you get hurt at work?
Any injury, even a paper cut, you know, probably your employee handbook says report it, and that's just the standard rule. Any type of injury, any type of pain, you know, report it to your supervisor, and then they'll let you know whether or not you need to fill out a form. But that's generally the golden rule.
Right. Yeah. And I think in reality, a lot of people don't feel comfortable doing that. So there is a 90-day notice requirement in South Carolina. And a misconception that I've seen, and you know that we've had clients who are worried because they didn't immediately report the injury, and then a week or 2 weeks have passed. You still have time. It's best practice to report injuries, especially if it's to the point where you feel like this is substantial. It's going to limit me. I need medical treatment. Then yes, report that immediately to your employer. But if something has happened and you didn't report the injury, it doesn't mean that you don't have a viable workers' compensation claim.
Yeah, and Tiffany's absolutely right. People feel uncomfortable a lot of times and put off what's in their best interest, thinking that it might affect their ability to work for the company or whatever else. But the more serious the injury, probably the more important it is to let someone know. And also, if there's no witnesses, then the quicker you report it, the better off you're going to be. If you use some of that 90 days, but people have witnessed what happened, it's not going to be an issue, hopefully. But if you're alone doing something, which happens all the time, and then you wait 2 weeks to do anything, it becomes problematic, and people start questioning what happened. So, right, just if there's no witnesses present, then go right away and let your supervisor know. And always good to have something put in writing. That could be a text, it could be an email, but just something so there's no question later on that notice was given.
Yeah. And
Along those same lines, I'm sorry, Tiffany, if there's a lot of, what do you want to tell people who are reluctant because they say, I don't want to sue my boss, I love my company, I mean, I've been hurt, but I don't want to bring a lawsuit against them. What would you tell them?
yeah, so I mean, it's not a lawsuit. You're not filing a claim. You're not saying that your employer did something wrong to cause your injury. You're simply filing a claim. Workers' comp insurance is there for that exact reason, that if you're injured while you're working, the insurance will kick in to make sure that you get the medical treatment you need and hopefully to help you get back to work in full capacity sooner rather than later.
Yeah, yeah.
Yeah.
Now, what if your boss comes to you and say, hey, listen, I don't want this to go on my insurance, just let me cover it. Just go ahead and go to the doctor, I'll take care of all the doctor bills.
Well, an employer can self-pay, send you to an urgent care or something of that nature before filing an official claim. But what you really never want to do is be pressured into going to the emergency room or urgent care and an employer scripting out, hey, tell them that you got hurt, working, you fell out of a tree at your house over the weekend. Don't ever be pressured into giving a false narrative on the history of your injury at work.
Yeah.
And that happens. That's Rick's bringing it up because we've all been there where somebody's come to us and said, hey, look, my boss said, that we should just treat this and put it under my health insurance. So I did that. I told them it happened at home, but it didn't. And once you start that slippery slope, it gets a lot more difficult. I mean, you still can come to a lawyer and hopefully get it fixed, but it goes without saying the truth is always the most important thing to do is to tell the truth with anything regarding injuries.
What if you're an independent contractor and you're working for somebody, but you just get paid for the work you do? Are you eligible for workers' compensation?
Not if you're truly an independent contractor, no. To make a claim for workers' comp insurance, you have to be an employee of a company. Even if you're titled an independent contractor, the factors the court looks at to determine whether you truly are an independent contractor. But if you are an independent contractor, you will not be eligible for workers' comp insurance under somebody else's policy. You could opt to have your own policy,
right.
And you could file a claim for that. But the fact whether or not you get paid in cash is kind of the second part of that question. That's not relevant in workers' comp in this sense. I mean, it is relevant, but in the sense that you're not going to be prevented from filing a workers' compensation claim just because you're paid in cash if you are an employee.
And especially like in the construction area locally, a lot of employees are misclassified as 1099 independent contractors, when if you really look at the test in workers' comp, they are definitely employees. They're told when to show up for work, they're using the employer's tools, they're being provided transportation, all the supplies are being supplied by the employer or a higher up contractor. So a lot of times people think I'm an independent contractor, but legally they're not. They're just an employee for workers' comp purposes.
Yeah, it's like Rick says, a 4-point test that they'll go through, but it really comes down to, does the employer have some control over the employee, over the worker?
Right.
And that's what will probably decide if it's an independent contractor versus an employee.
Today we're going to run to a break here real quick. When we get back, we would love to answer all of your questions about workers' compensation. Remember, if you have any overall questions, please contact a personal injury law firm, because consultations are free as far as workers' compensation are concerned. So call somebody to get help that you need and that you want. Or you can give us a call and we'll give you the needs that you want or the answers that you want right now. Numbers on your screen. We'll talk to you in just a minute here. It's Legal Access, brought to you by the Maguire Law Firm. Welcome back. It's Legal Access brought to you by the Maguire Law Firm. Our topic today is workers' compensation. If you have any questions, don't be shy. Call us on the number you see on your screen, and we'll get those questions answered for you here. Now, as far as full-time versus part-time, I mean, if you've got, if you're an official employee, I understand that you are eligible for workers' compensation. But what if you've got two jobs? You're full-time here, you're part-time on job B. If you get hurt on job A, are you still eligible to make up for the money that you're going to be missing from job B?
Yep.
Yes, yeah. So if you have a concurrent employer, whenever your wages are calculated, both employment revenues will be used in calculating. There are situations where maybe one job is a heavier duty job and the other one is a desk job. So there are situations where you can still work your secondary job, and then the calculations for what you're owed might be a little different. But I will say that the onus is on the employee, that the injured worker. If you have concurrent wages from a second employment, it is imperative to get those wages and give it to the adjuster for the workers' comp claim, because the adjuster is not going to proactively go out and find out what your secondary wages are. So that's something that's kind of the burden is on the injured person to prove what their their concurrent employment wages are, and make sure that that's included in the workers' comp claim.
Yeah, that happens a good bit where somebody will come in to our office later on in a claim, and they had a second job that and where they made sometimes even more money than the job that they got hurt at. Well, that's going to dramatically change the value of their case and their benefits. Mm-hmm. And it's something that's somewhat unique to South Carolina. North Carolina doesn't allow employee to do that. In a lot of states they do. A lot they don't. You just got to go state by state, but it's unique for around here in these areas, the southern states. It's somewhat unique, and it's really a good benefit for the employee, but also it's fair.
Yeah.
Because if you're out of work, you're getting 2/3 of your average weekly wage, and the way that computes is it's not getting taxed, right? So it should come out somewhat near to what you were making. But if you didn't have that second job included, then it's going to be really a rise. It's going to be really off. So but somebody will come in the office. The adjuster, as Tiffany said, will not usually say, "Oh, do you have a second job? Let's compute that and put that," and it makes such a big difference. So if that's the case, you definitely, and it doesn't hurt at all the job that the employee wasn't hurt at. It's not hurting them at all. All they got to do is provide the wage forms, and that's it. They're not getting hit at all from it. So it's just the insurance company for where the injured person was working.
Now, for people who haven't been through this process, I mean, if somebody gets injured and they go to the Workers' Comp Commission, do they get assigned a caseworker, or do they handle and stuff for the individual, or what happens?
Day to day, the claims are being handled by an workers' comp insurance adjuster. Sometimes they'll proactively hire a law firm to assist them in the claim. But the Workers' Compensation Commission doesn't get actively involved in a claim until either side, either the employer, insurance company, or the employee or their attorney request a hearing. And then a hearing scheduled, a commissioner is assigned, and the commissioners rotate throughout the state on a schedule. Regionally, they usually come to Conway, but Georgetown, the major cities.
Yeah, and so until that happens, like usually there won't be an attorney on the other side. But as Rick said, there's certain cases where right away the insurance company will assign an attorney to get involved, and frankly, it's usually things are a lot cleaner when there is attorneys on both sides involved. I think.
I think so too. Yeah, and sometimes there's a nurse case manager that's assigned, but that's not somebody that's assigned by the Workers' Comp Commission. That would be assigned by the insurance adjuster. And the nurse case manager is not an attorney. They are not advocates for you. They are there to help assist and facilitate treatment. So if the doctor orders an MRI, they'll make sure they get the order, get that scheduled. So a lot of times the nurse case managers can be very helpful with facilitating treatment, but they're not going to actually help you through the legal process.
And they are hired
Yes.
and paid
Yeah.
by the insurance company,
Yeah.
which, back in the old days, pre-2007, Rick, they, you would be able to say to the nurse case manager, we don't want our client having a nurse case manager. Those days are over, so you really want to try to work. And most of them are, they're people that are really interested in getting somebody better, and they're doing whatever they can to facilitate that. It's very rare that there's issues but you do have to be aware that they are not hired by, the plaintiff's attorney or the injured claimant. They're hired by the insurance company.
What kind of injuries or workplace accidents would fall under workers' compensation? I mean, if I went to the break room at my job and I was cutting a bagel for lunch and I accidentally cut my hand, is that going to be something that could be potentially covered?
Yeah. So, under the statute, it's literally an injury by accident occurring in the course and scope of employment. So, it's not always something catastrophic or, a traumatic injury. A lot of times, I would say the vast majority of workers' compensation claims, are like back strains where you're picking something up and you strain your back, and then that kind of turns into life-altering injury, or maybe you get better. But a lot of the claims are just accidents. It's not that somebody caused your injury or was negligent, and a lot of times the injured worker might have kind of contributed to the accident by not being as careful as they could have been, and that is not going to be a defense to the case.
That's why I buy pre-sliced bagels, by the way. So
And the exception would be a horseplay situation. I pull out your chair, you get up, you punch me. If I initiated and started the horseplay, it very well may be something that might be denied. But it's supposed to be construed liberally, as Tiffany said, and you don't have to prove fault like you would in a case if it was a third-party type case. So, there's a lot of parts of workers' comp are favorable to the employee and the insurance company too. It's sort of a balance, but that's one thing that's favorable to the injured person, and that is that you don't have to demonstrate who's at fault. It's just as long as it's untoward or unplanned event.
And Tiffany, you mentioned back injuries. I understand, though, through a little birdie, that injuries like hernias are very hard to prove as far as workers' compensation goes.
Yeah, I don't know. Yes, it can be, and it's not so much the proof element, but more so the permanency element. That under workers' comp, you don't get pain and suffering or loss of enjoyment of life at the end. Whenever you ultimately get an award, it is based on the permanency of your injury. So if you have a hernia, you might have to have treatment for the hernia, but usually it doesn't impact other body parts. It's not going to prevent you from working or cause work restrictions or any type of permanent impairment. So those cases are a little different under the workers' compensation statute.
All right, going to run to another break here real quick. We've still got just under 10 minutes left. If you have any last-minute questions about workers' compensation, now is your chance to give us a call, because you've got to get in before the last commercial break comes up. We've got another commercial break right now. We'll see you in just about 90 seconds right here. It's Legal Access, brought to you by the Maguire Law Firm. It's Legal Access, brought to you by the Maguire Law Firm. Workers' compensation, that's our topic here today. Give us a call, 843-848-8080 on our panel to answer the questions for you. From the Maguire Law Firm is Ian Maguire. Also from the O'Neill Law Firm, Rick O'Neill, and Tiffany Buffkin from the Maguire Law Firm as well.
All these Irish names get all
Yeah.
confused.
Sorry about that. All right, let's talk about third-party cases. If you are driving a vehicle for your employer, get hurt in an accident, and it's the other driver's fault, how does that affect a workers' compensation claim?
Well, that's a third-party claim. So it's actually, you have two claims going at the same time, but they overlap. Generally, in the workers' compensation claim, that's where you're going to get your ongoing treatment. If you're out of work, that's where you're going to get your out of work pay and so on. But the auto claim, you still have to meet all the deadlines on that and get that set up. And there may be a property damage claim involved in that, but they overlap, and it's tricky. The one thing you don't want to do is settle your auto claim or your slip and fall claim while you have an ongoing workers' comp claim, because if you would settle that claim, that civil claim, it may extinguish your right to continue to get any more benefits under workers' compensation. So generally, it's really a good idea, even if you're not going to retain an attorney, go do the free consultation that most workers' comp lawyers will do, and get all the facts on what you can and cannot do, and the strategy on the timing of settling the claims.
Yeah.
As far as the final settlement is concerned for workers' compensation, if you're going to be needing some additional surgeries down the road, how do they figure future medical costs?
Yeah, so it's really case dependent. A lot of cases will settle, and workers' comp is unique because you can settle with open medicals. So there's a settlement in which you don't really have to worry about what the future cost of medicals are, because anytime you need medical treatment, the carrier will cover it, even if it's 10 years after you've settled your case. There's a second settlement avenue, which is a clincher, which is a full and final settlement where the adjuster will pay you additional money to close out the future medical treatment. And really valuing that there's not like a strict calculation to find out how much your medical treatment will be in the future, unless you're a Medicare recipient. If you're a Medicare recipient, then the cost of future meds will have to go through CMS for approval. But generally, you just kind of, if you know what the doctors have recommended, you can look. Midlands Orthopedic has a cool tool up there. They've been promoting transparency and cost and pricing, so you can go and actually look up what the cash value of a lot of the procedures are, and you can add all of those together and send demands and work out what a reasonable price is to close out your future medicals.
But the burden of you as the employee to plan and be compensated for any possible future medical, that's the proof of that is on you.
Yeah.
And you're not guaranteed, you settle your back claim, you don't need a back surgery now, you're too young, and 5 years from now you need a back surgery. Unless it's been spelled out in black and white, you're not 100% guaranteed that that's going to be covered by workers' comp in the future. So whenever you have a claim where you think there may be the need for future treatment in the future, whether it's for arthritis or surgery, something like that, you really need to again, get a free consultation or get representation of an attorney so you can plan that and have the proof and get it in the orders. That's an option.
If the order is not going to allow you to have your case stay open for that purpose, then you should get compensated at some level for it.
Yeah.
All right, we appreciate you watching here this week as we've been talking about workers' compensation. If you have any questions we couldn't get to on the air, make sure you give us an email, legalaccess@WMBFnews.com. Next week when we get together, we're going to be talking about automobile accidents, something that we're all too well acquainted with here. I want to thank our panel for being with us here today. Ian Maguire, also Rick O'Neill, Tiffany Buffkin. My name is Dave Priest. We'll see you again next week. Automobile accidents is going to be our topic then, and we'll also hear more about Summer Without Hunger from Salvation Army next week as well, right here on Legal Access, brought to you by the Maguire Law Firm.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information provided in this program is purposefully broad and does not constitute legal advice. Please contact and retain an attorney in order to obtain case-specific